So I'm going to read. This is 26 pages, but there are a few pages that we don't need to cover because they're stuff that only a lawyer will understand, if that. And we certainly will not understand it. But anyway, there are a few pages like that. But most of it, 90% of it, a layperson can. Did I just say layman? Layperson. Let's take with layman. Layman can understand. But this is the court case where the Family Federation attempted to, well, they actually sued the World Peace Unification Sanctuary back in July of 2018 in the Middle District of Pennsylvania. And this has been at the district court level now for almost 4 years. It'll be 4 years in what? It would have been 4 years, just 4 months from now. So almost 4 years it's been in that district court. And both sides have spent literally millions of dollars. I think we probably spent around $2 million, maybe a little bit less. And I'm sure people who sort of have experience in this area tell us that given the lawyers that they were using, they must have spent a lot more. In other words, Family Federation must have spent a lot more than we did. For one thing, their lawyers have their offices in a high-rise building in Rockefeller Center. We used a Midwest law firm, which, hey, they won. they got it for us. And the end result of this is that the Middle District of Pennsylvania Judge Jennifer P. Wilson, God bless her, dismissed the entire case after 4 years, after having it on her desk. Well, it wasn't on her desk for 4 years. It was on her desk about 3 years plus, 3 years and a bit, because it started out with another lawyer, another judge. He retired after having it for just 6 months or 5 months or something like that. And then she took it over, and she was a brand new judge at that time. And so she's been studying this case for a long, long time. And both sides have submitted, file after file after file after file after file. And that's where the millions of dollars comes from. And we've had depositions. Each side deposed 7 people, I think, on the other side. We deposed 7 of their people. They deposed 7 of our people, and I was one of them. And one of the people that we deposed on their side was Hak Jahan. And she gave a deposition that lasted 10 hours, on camera 10 hours. And that was spread out over two days. And I attended that deposition. Much of that deposition, much of the transcript of that deposition has been made public. Some parts have not been made public, and I'm still not allowed to speak about the parts that have not been made public. But even the parts that have been made public have caused quite some, I guess, some surprise, perhaps some consternation on the part of people who love True Father and love his providence. You may have seen videos of Hak Jahan giving a deposition. That is not this case. That is another case. Those videos pertain to the case, a separate case, where Family Federation is suing Preston's group, UCI. And the deposition that she gave in that trial was made public. The video, I don't know if it's the entire video, but the entire video was made public. We asked the court to make this deposition video public, and Family Federation argued against it, and the judge came down on their side in that particular case. And so the video of Hak Jahan's deposition in this case has not been made public. We continue to hope that situation can change, and we will do everything we can to somehow get that video released at some point in the future, because it's important. Because the transcript, of course, is basically the words of the translator, and I was there, and in my assessment. Well, there was a court translator, and then she brought her own checker translator, and then I was the sort of the second checker translator for our side. And most of the transcript is actually the words of Hak Cha Han's own checker translator. And I can't blame the court translator. She tried her best, but this is not a usual case. A lot of terms and phrases and everything like that the court translator was completely unaware of. And so the checker translator for the Family Federation had to correct her a lot. And I found very little cause to correct the checker translator after he had spoken. Once or twice I did, but it was pretty rare. So it'd be good to get that video out. But as I say, in my assessment, the translation of her words is quite accurate. I would say quite accurate. I think could be, and it's accurate because most of it is the words of their translator, Family Federation's translator, who was correcting the court translator. So let's see what the judge said about this case. So this is in the United States District Court for the Middle District of Pennsylvania. And that means it's a federal court. The reason it's a federal court is that this had to do with trademark law, and trademark law is federal law. And so that is why when the Family Federation decided that they wanted to sue us, they had to go to a federal court. And it's the Holy Spirit Association for the Unification of World Christianity, because the Family Federation's legal name is still HSA-UWC. They have not changed their actual legal name. Family Federation for World Peace and Unification is actually kind of what they call a DBA, doing business as. So the legal name is HSA-UWC, but the name that they use in public and sort of do business as is the FFWPU, versus World Peace and Education Sanctuary, Inc. And this, of course, is the organization that the second king founded in March of 2013 in order to carry on our father's tradition and to establish his own ministry that was loyal to father. Okay, and then this is the name of the judge, Judge Jennifer P. Wilson. Okay, let's see what Judge Wilson said about this situation. Let's see here. Before the court are cross motions for summary judgment. Because of the court finds that it cannot resolve the merits of these issues presented in either motion, the court will dismiss this case for lack of subject matter jurisdiction on ecclesiastical abstention grounds. And the phrase ecclesiastical abstention, and I'm speaking today as a layman. I'm not a lawyer, never been to law school, never even stepped on a law school campus. But I'm a layman who has, I guess, kind of had a crash course in some small part of the law over the last few years, I guess. Anyway, ecclesiastical abstention. This is a doctrine of American jurisprudence, which says that because the First Amendment says that Congress cannot establish any religion, in other words, cannot favor any religion, and so therefore this applies also to the courts. And so the courts cannot, so based on that, the courts cannot get involved in any sort of internal dispute within a religion. So the court, for example, cannot decide who's the legitimate leader of a religious organization. The court cannot say who is following the correct theology of that particular religious organization. And whether it's Buddhist or Christian or Islam, the court cannot say, okay, you guys are right and you guys are wrong, and this way. So that is the doctrine of ecclesiastical abstention. So on that grounds, the court, after almost 4 years, said, you know what, we can't do this. We cannot decide who's in the right here. So here, let's go through the factual and procedural background. She got most of this right. A couple of places but anyway, I would say she got 99% of this right. Reverend Sun Myung Moon founded the Unification Church in Seoul, Korea in 1954. Okay, so that's something we both agree on. The Unification Church expanded quickly, forming branches throughout the world, including the United States, and is now a global religious organization. In 1960, Reverend Moon married Hak Jahan, Hyungjin Moon, also known as Sean Moon, and Sean is the shall we say, the American name that, or the English name or American name that Hyungjin has been using since childhood, is one of Reverend and Mrs. Moon's sons. Plaintiff, HSA UWC, or HSA, was established as a branch of the Unification Church in the United States in 1961. Since 1961, HSA has expanded to 109 chapters with over 16,000 members in 50 states, including Pennsylvania. Okay, so, you know, the number is right, okay. 16,000 members of HSA today. All right, so, you know, all religious organizations, you know, I count us as exception. You know, when we give our numbers, we try to do good faith estimates, but obviously 16,000 in 50 states, 109 chapters, that stretches it pretty far. Anyway, but be that as it may, okay, be that as it may, we don't need to fight over that. According to HSA officials, the Unification Church does not have and never had denominations. However, HSA oversees and has overseen the establishment of local churches throughout the United States in accordance with its governing documents, including the National Charter that was in place in 2013. In 1965, Reverend Moon created the 12 gates or Tongyo symbol, which appears below. Now, the Family Federation, I'll go ahead and call it Family Federation since that's what most of you are familiar with. Family Federation calls it the 12-gate symbol. And I know this was what it was called, I guess, historically in America. I don't know where that came from. I don't see anything in Father's words to describe this as a 12 gates symbol. But somehow, somewhere, someone decided that this would be a good way to express it in English. That's not the word that Father uses. And personally, I prefer to go with what as close as possible to what Father says. And Father calls it the Tongyo Maku, the Tongyo mark. But the word mark has certain legal meaning in American law. And so for that reason, in this case, I asked our lawyers to call it the Tongyo symbol. And so that's as close as we can get to what Father called it without causing undue confusion. Okay, Tongyo symbol, which appears below. The image was designed to be the symbol of the Unification Church's activities and to be used broadly for all witnessing, public relations, service activities, church activities, and our websites. Indeed, the Unification Church has used the 12-gate symbol for over 50 years to identify its religious services, and the symbol is used in all aspects of its members' lives. HSA and its local churches use the 12-gate symbol in connection with holidays, ceremonies, major events, and on blessing rings that serve as public displays of marriage through the Unification Church. Many HSA local churches also display flags or signs with the 12-gate symbol outside their buildings. In addition, the 12-gate symbol is displayed at the entrance to and throughout HSA's offices and at important HSA locations. While the 12-gate symbol is usually red, as pictured above, it has also been displayed in a variety of colors, including including on gold jewelry. And you can tell that the judge here is excerpting from documents submitted by Family Federation. But I think these are probably, in my understanding, lines or content that we did not contest on our side. On June 30th, 2009, HSA registered the 12-gate symbol with the United States Patent and Trademark Office for religious prayer services and so forth and so on. And as of October 7, 2019, the 12-gate mark was still registered, active, and owned by HSA. And that's still true today. According to HSA, limited use of the 12-gate symbol is permitted by the Unification Theological Seminary, HSA's seminary, and Gary Fleischer, an HSA member who uses the symbol on his website, which archives Unification Church documents. Around 2001, Reverend Moon created the phrase Chunju Pyongwa Tongyuguk, or in shorthand, Chunuguk, which roughly translates to Kingdom of God or One Heavenly Nation from the Korean language. Like the 12-gate symbol, HSA asserts that the phrase Chunuguk has been fully integrated into its activities, including the Chunuguk Constitution, the Chunuguk Anthem, its Chunuguk leaders, and its Chunuguk calendar years, as well as publications, banners, and merchandise. The phrase has also been incorporated into another symbol for the Family Federation for World Peace and Unification, which appears below. And here's their Chunuguk symbol. And obviously, this is a symbol that is quite foreign to those of us who follow Father's tradition. And if they want to use this, we have we would never use this anyway. So this symbol is not a part of the controversy. On September 14, 2015, HSA applied to register Chunibuk as a trademark with the USPTO, but these proceedings have been stayed pending the outcome of the instant litigation. Now, the interesting thing in 2015 was, as the judge says here, HSA applied to register Chunibuk as a trademark. In other words, there was an attempt here to cause trouble for us so that we could not use, the sanctuary could not use Chunibuk. Yeah, that's talk about authoritarian dictatorship. You can't, what? So in other words, if we were to print the pledge, we would have to say, our family, owner of ... We could not use the word Chunibuk in the family pledge. We could not print the family pledge with the word Chunibuk in it. I mean, that is a ridiculous situation that would have happened, or could have happened, or probably would have happened, but now it's not going to happen, as you'll see, because their attempt to monopolize the colonial symbol, their attempt to monopolize the phrase Chunibuk has been squashed by the Judge Jennifer P. Wilson. Praise God for her. Of course, they have the right to appeal. They have the right to appeal, or they have the right to file a motion to reconsider, I understand. But hopefully, wiser minds will prevail, and they will say, okay, let's stop this nonsense. We've already spent millions of dollars on this, and we lost, and that's it. Let's hope that they go that path. Anyway, so the attempt was to also monopolize the phrase Chunibuk by registering that as a trademark. And the interesting thing is that about a week after September 14th, one of our sisters, who is a patent lawyer, was just one day, I guess, spirit world inspired her. She was wondering, gee, I wonder what mischief the Family Federation is up to. And so she went into the USPTO database and did a search on Family Federation and discovered that this application had been filed just a week before. And so she notified headquarters in Newfoundland, and we thought, wow, we need to do something about this. Well, what are we going to do? Because we had never done any sort of legal, real, of course, some fundamental legal work in establishing the corporation, stuff like that, but no fight like this. And so what were we going to do? So we sought Cook Jinim's advice, or the advice of Jim Borer, I guess, who was legal counsel for Cook Jinim's organization. And they had a lawyer that had helped them in the past with some copyright issues. And so we contacted her, and so she explained to us the process. And within the USPTO process, there has to a certain amount of time has to pass before people like us can challenge the registration of a trademark. But in the meantime, we went ahead and filed a letter, some sort of letter of opposition or something like that, which that lawyer helped us with. But anyway, we were hoping that the USPTO would reject this registration, but they didn't. They said, okay, well, you meet all of the qualifications. And so then they published it for opposition. In other words, they published it, but then it wasn't officially registered yet. It was just published it so that members of the public, including us, could then say, hey, wait a second, we don't think that should be registered. So when that happened, then we went forward and we took the case to the what amounts to the administrative court of the USPTO. And then later on, and as that was happening, Family Federation decided to sue us in July of 2018. And so then when we responded to their suit, we asked the judge in the Pennsylvania case, which the Family Federation was suing. We asked the Pennsylvania judge to roll this patent and trademark case into the Family Federation's suit against us. And the Family Federation tried to argue against that. And the judge said, well, hey, come on, HSA, you guys gave Sanctuary the opportunity to do this, and now you're saying they can't do it. So no, we reject that. So the judge said, okay, we're going to roll this into the whole July 2018 suit. And so that's how this came before. And then that judge retired, and this Judge Wilson came in. So that's how Judge Wilson came to deal with this Chernobyl situation as well. And so when she dismissed the entire case, then we'll see what happens. But she did establish the doctrine of ecclesiastical abstention. And so we'll see how their application with the USPTO plays out. We'll see what happens with that. I have certain opinions about that, but maybe it's better if I don't share them right now. Anyway, we'll see how things play out. Anyway, so here, Tony said in 2014. I'm going to say 2015, September 14th, applied. All right, Reverend Moon, the founder and creator of Unification, has passed away in, let me just move this over here, in September 2012. All right, thereafter, Sean Moon disputed Mrs. Moon's authority to lead the Unification Church. That's right, and formed and defended World Peace and Unification Sanctuary around 2013 with the stated mission of spreading Reverend Moon's teachings. Yes, so now the judge is quoting from our documents. Sanctuary is a separate entity from HSA with its own certificate of incorporation, bylaws, and governance structure, all of which are unauthorized under HSA's national charter. Okay, we don't dispute that. As part of its work, Sanctuary promotes two ministries: religious services, which Sanctuary classifies as the practice of unification. Unificationism that promotes the teachings of Reverend Moon, but rejects Mrs. Moon's ability and qualifications to oversee the Unification Church. And if you want sort of more detail on that, I refer you to my remarks on To Parents Day last Friday. Okay, that'll explain why Sanctuary rejects what they call here Mrs. Moon's ability and qualifications to oversee the Unification Church. And second ministry then is Rod of Iron Ministries, which is intended to target a broad audience of Christians who believe in the use of firearms, but who may be less interested in or familiar with the theology of the Unification Church. As part of both ministries, Sanctuary utilizes the 12-gate symbol to the same extent as HSA. However, I would say that we use it quite a bit more than the HSA. HSA, I think, is using it just barely enough to maintain their trademark. Because if they abandon it, then we'll be in there to swoop it up. So they don't want to. They want to make sure that doesn't happen. However, Sanctuary primarily displays the symbol in gold, although we sometimes do it in red. The 12-gate symbol appears on Sanctuary's signs and websites, including its YouTube channel, on which it broadcasts its services, or at least we once did, until YouTube banned us. Anyway, now we're on Twitch and Rumble. The 12-gate symbol is also incorporated into the new symbol for Sanctuary's Rod of Iron Ministries, which appears below. Okay, there we go. Yeah. And if, during the deposition, I think it was during Richard Panzer's deposition, the Family Federation lawyer said, well, how would you feel if Family Federation were to start using your symbol, your Rod of Iron symbol? And Richard said, hey, that would be great. that would be progress. Yeah, they can use this anytime they want. Sanctuary's basic philosophy or policy is that the Word of God belongs to all of God's children, even the bad ones. All right. So if the bad, disobedient, betrayer children of God who still belong to Family Federation want to use this symbol, they can do that. They have the right to do that. And we will not contest it. We will never try to register this as our trademark. We have not, and we will not. This symbol is also used in Sanctuary signs and websites, including its YouTube channel. Thus, Sanctuary has used the 12-gate symbol in various iterations since its inception. In 2015, HSA submitted a complaint to YouTube requesting that Sanctuary's videos depicting the 12 gate symbol be removed as infringing on its trademark. YouTube declined to remove these videos. Interestingly, Family Federation actually submitted 2 channels that they wanted closed down. One was the church's official channel, and one was the king's personal channel. And YouTube closed down the personal channel, but not the church's channel. I found that interesting. But anyway, yeah. Thereafter, on May 3rd, 2016, HSA sent Sanctuary a cease and desist letter requesting that Sanctuary immediately stop utilizing the 12 gate symbol in connection with its activities. Sanctuary responded to this letter on May 31, 2016, asserting that, quote, any and all assets of HSA UWC, including all trademarks and symbols, remain under the authority of Sean Moon. Bingo, yes. And that's still our position. That is still our position. And that was the basis of a suit that we filed as a kind of a countersuit. So the way it happened was that in 2018, HSA, or Family Federation, sued the king. And so then, as a part of our defensive strategy, we countersued the Hak Jahan and Family Federation in a federal court in New York, in the Southern District of New York. Now, saying that what this sentence just said, hey, all assets properly belong to Sean Moon because he is the sole legitimate heir and successor to Reverend Sean Moon. Now, the Southern District of New York dismissed that suit. We appealed to the second district. The second district dismissed the suit. We tried to go to the Supreme Court. The Supreme Court chose not to hear our case. And so that ended. But there too, the reason they dismissed it on the basis of ecclesiastical abstention. So you see what has happened here now? 3 federal courts, Southern District of New York, Second Circuit Court of Appeals, and the Middle District of Pennsylvania. 3 federal courts have now concluded that the court system of the United States cannot intervene in the struggle or the struggle between Family Federation and Sanctuary Church. So that is I consider that to be a very important foundation for the king now. After the Southern District of New York, and especially after the Second District came out with their dismissal, I know people in the Family Federation really popped the champagne, whether it was non-alcoholic or not, I don't know. But anyway, popped the champagne bottles and said, yeah, we won. Now Sanctuary is gone. But what happened though was that we were able to, before the Middle District of Pennsylvania made its decision, we were able to establish in the New York courts this doctrine of ecclesiastical abstention with respect to this fight between Family Federation and Sanctuary. And you will see later in this decision, if I have time, I hope I get there today, that the Judge Wilson actually quotes from the Second District decision to dismiss. So now the overall picture, okay, is that 3 courts have said, hey, ecclesiastical abstention, cannot get involved in this. 3 courts have said that. So what that means now, in my opinion, my layman's opinion, is that Family Federation tried to use the American court system to quash Sanctuary Church. And that attempt by the Family Federation has now failed. It has failed, conclusively failed. If they want to actually win, they have to be more loyal to Father than we are. Try that. That's an idea, right? That's an idea. Be more loyal to Father than we are. Let's have a competition on that scale. And let Father decide who wins that competition. Okay. Let Father decide who wins that competition. Good luck with that, because we're already way ahead of you. We are already tens of thousands of miles ahead of you on that one. You haven't even started the race. You're actually going in another direction. Anyway, let's not get too excited here. All right. Okay. Well, it's hard not to, because this really is a wonderful And so one of the things, so someone might say, hey, you guys won one, but you lost two. No, we won the war. We won the war. Okay. We won the war. The war is over now. Now, Family Federation may try to appeal to the Third Circuit Court of Appeals. They may try to make it, hey, let's go for four. Let's go for a fourth court. But it's almost a done deal that this fourth court, if they try to go to the Third Circuit Court of Appeals, they're going to say, what? This has already been decided. It was decided by the Southern District. It was decided by the Second Circuit. And now it's decided by the Middle District. So what are you guys doing now? What are you taking up our time for here? Anyway, so any and all assets of HSA UWC, including all trademarks and symbols, remain under the authority of Sean Moon. And we will continue to claim that and insist that. And this will be proven correct. On September 22, 2016, HSA responded to Sanctuary's May 31st, 2016 letter stating that at no time while Sean Moon was president of HSA UWC or after he resigned from that office, did HSA UWC assign or license the 12-gate symbol or any other mark to Sean Moon or Sanctuary. Well, guess what? Father did. Father did. Father did. Based on the record, it does not appear that any other efforts were made to curtail Sanctuary's use of 12-gate symbol until the instant lawsuit was filed on July 30, 2018. On February 28, 2018, Sanctuary held a blessing ceremony involving, quote, Sanctuary's congregants carrying semi-automatic guns as part of the ceremony. Okay, guilty as charged on that one. The 12-gate symbol was prominently displayed during the event. Certain news outlets reporting on this event initially indicated that Sanctuary was associated with the Unification Church, a fact which HSA vehemently disputed and continues to dispute. Okay, so the news media got it wrong. Okay? Has that ever happened in history before this? No. Yeah, the news media gets stuff wrong all the time, but people don't run to the court every time that happens. HSA has since undertaken efforts to clear up this alleged confusion, including by issuing press releases, letters to news outlets, verbal corrections, and the institution of the instant litigation. All right, so you've made your point. This action was initiated by a complaint on July 30, 2018. Sanctuary responded with an answer and counterclaims against HSA on September 26, 2018. And HSA moved to dismiss Sanctuary's counterclaims, but this motion was denied by United States District Judge Robert D. Mariani on July 22, 2019. So he was the first judge before Judge Wilson to deal with this case. By agreement of the parties, the court permitted HSA to file an amendment. So let's, I don't have much time left, so let's go down here to the discussion standard of review. We certainly don't need to do that. That's the part that only lawyers will understand. Okay, and discussion, okay. In HSA's motion for summary judgment, HSA argued that 12-gate symbol is a valid trademark to which Sanctuary has no colorable claim, that Sanctuary infringed on HSA's trademark rights to the 12-gate symbol, and that Sanctuary has no valid affirmative defenses to HSA's trademark infringement claim. Specifically, HSA asserts that it is the exclusive owner of the 12-gate symbol by virtue of its trademark, registered at this number, issued on June 30, 2009, and is unrevoked, and so okay, and so forth and so on. Sanctuary's motion for summary judgment, in contrast, argues that 12-gate symbol is a generic or universal religious symbol akin to a cross or Star of David, which is not subject to trademark protection. That's right. We tried to make that claim, and I think we can still make that claim. Specifically, Sanctuary asserts that the 12-gate mark conveys affiliation with Unificationism, not a particular sect within Unificationism. Sanctuary also argues that HSA has abandoned its trademark rights by permitting the unlicensed use of 12-gate symbol. Indeed, Sanctuary asserts that it has used 12-gate symbol since its inception without any enforcement action taken until the instant litigation. That's right. So it was 5 years, more than 5 years after the second king began his ministry, and began using the Tonyo mark, that HSA finally got around to suing him for it, even though they knew that this was going on. Sanctuary raises the same arguments with respect to Tonyo, okay? And finally, Sanctuary argues that the court should abstain from resolving any of the disputes raised in this litigation on the basis of the ecclesiastical abstention doctrine because of its affirmative defenses. Okay, so then, yeah, we basically said, listen, the Tonyo mark is ours, but if you can't accept our defenses, then you should at least dismiss the case. And that's what the judge finally wound up doing. So I wanted to go to where she quotes from the Second Circuit, and she explains about the ecclesiastical abstention and stuff like that. Okay, and she talks about the third district. Okay, and she says, HSA says that you don't have to, you can still do this, but okay, and then talk about something called the Lanham Act. So anyway, she says though that let me see if I can go down here to where we have almost no time left. So if you want a copy of this, I've already given it to all the continental leaders. You can contact me, you can contact Richard Panzer, or you can contact your continental leader in your particular area, and they can provide this to you. And I think it's going to be posted on our website as well. There's been some suggestion to that. And here, yeah, okay, here we go. Plainly, this is a dispute that the court cannot resolve without venturing into issues of church leadership or organization, an area in which the Southern District of New York and the Second District have already determined is inappropriate in a similar dispute presented by the same party. So you see, she is using the Southern District of New York and the Second Circuit as foundation for her decision as well. And let's hear Hyung Ji-moon versus Hak Ja-han et al. Actually, and the Southern District. And also, so here, so that is how we can say that it was by losing in the Southern District. In other words, losing meaning that having our case dismissed in the Southern District of New York and having it dismissed at the Second Circuit level, we were able to create a foundation for a victory in the Middle District of Pennsylvania. So I don't know if you can put all that champagne back into the bottle, you guys, Family Federation, but yeah. All right, I gotta go. It's time to go. But I'm pretty sure this is going to be on our website at some point. This is a very historic document for us. And so based on this victory, the king is now going to be touring Korea, hopefully Japan, and perhaps other countries as well in the future, because this victory puts the king's work, his mission, into an entirely new era. It's really significant that this victory came 2 days before the 63rd True Parents Day. All right, I gotta go. Now from 10 o'clock, I'm giving a Constitution lecture. And then as soon as that's over, we're gonna get on the highway and point our nose northward and try to get up to Pennsylvania. But we're making a stop on the way, so we want to actually be in Pennsylvania for another couple of days. Please continue to pray for the king as he prepares his tours in Korea and Japan. And I'm sure there will be some people who will be praying to the opposite effect. That's all right. Controversy is good. Controversy creates news, and news helps us spread the message. All right, I gotta go. It's 1 minute past 9. God bless, Godspeed. May his kingdom come quickly.